Oyez, oyez, oyez. All persons having business before the Honorable, the United States Court of Appeals for the District of Columbia Circuit are admonished to draw near and give their attention, for the court is now sitting. God save the United States and this honorable court. Case number 20-1183, American Federation of Government Employees, Local 3690 Petitioner versus Federal Labor Relations Authority. Mr. Davis for the petitioner, Ms. Blackadar for the respondent.
Mr. Davis, good morning.
Good morning, Your Honor. May it please the court, my name is Joshua Davis, and I'm here on behalf of the American Federation of Government Employees, Local 3690, Federal Correctional Institution, Miami, Florida. Today, I come here to you, Your Honors, to discuss the Federal Labor Relations Authority, who from here on out I'll just refer to as the authority. The authority's patent refusal to follow the Steelworkers Trilogy as laid out by the United States Supreme Court. Further, I come to let this court have its say on the practice known as augmentation. This is a practice that has affected the institution and the workers that I represent greatly. And it's a practice that was explained in the briefs, but for brevity's sake, where the Bureau of Prisons takes teachers and turns them into maximum security prison guards and the like. I think the first thing and the most important thing to address this morning is that this court does have jurisdiction to hear this argument. The issue of the Memorandum of Understanding was brought before the arbitrator, was addressed before the authority, and the authority's slight mention and what seems to be acceptance of the repudiation of the Memorandum of Understanding is clearly within the bounds of what a ULP needs to be in order to come before this court. Now,
but you did not, counsel, you did not litigate this in allege an unfair labor practice before the arbitrator, correct?
We did not use the words unfair labor practice. We used breach of the Memorandum of Understanding. Now, under the authority precedent, there can be two sorts of repudiation, an explicit or an implicit. In this case, it's the union's position that there was an implicit repudiation. And the authority's test for that is the nature of the violation and whether the violation goes to the heart of the party's negotiated agreement. In this case, this MOU, which is petitioner's appendix, page 197, it was made after the union and the agency had collectively bargained their initial agreement. And on number 2 of that MOU, it clearly states, unless mutually agreed, all matters brought forward at FCI Miami will be negotiated in the order based upon the date the intent to negotiate was filed. Once an intent to negotiate has been filed, the agency and the union will mutually exchange proposals within 45 days. If an issue of negotiability is raised by the agency following the exchange of proposals, the agency will provide the union with written notice of the issues deemed as non-negotiable. This notice will include specific references, case law, master agreement as to why the specific issue has been deemed non-negotiable. The union at FCI Miami, relying on this Memorandum of Understanding, which was entered into between the parties, attempted to raise the issue of augmentation with the agency. But the agency did not follow this contract at all. All they said was, we're not going to negotiate. They provided no case law. They provided no insights. They did not follow this. And when it gets to the second branch of the authority's test for repudiation, Article 2 of this MOU goes to the heart of the entire agreement, because without knowing what matters are on the table in order to negotiate according to the rules for the rest of the MOU, there is no logical way for the rest of the agreement to exist. And it's a well-recognized canon of statutory and contractual interpretation that we give meaning to as much of it as as much of the document as we can. And
Mr. Davis, if
yes,
I
sir.
could interrupt for a moment, how much of what you just said was argued to the authority?
In the exceptions, petitioner's appendix 148, and the opposition to the exceptions, the very first thing that the union really argues is that, hey, this has been decided on separate and independent grounds other than what was accepted to by the agency, and therefore this needs to be addressed. The union cites actually on 148 that, I'm looking for the actual word repudiation, I'm sorry. The union in its opposition, I found it. It's actually petitioner's appendix 149, the last paragraph of the page. The union actually cites in comparison a FLRA case where the authority found that the agency had in fact violated 7116A1 and 5 of the statute after it unilaterally repudiated the party's local memorandum of understanding. This court's precedents and this court's holdings, even as recently as the NLRB case that came out a couple of days ago, show us that this was enough to put the authority on notice that this was an appealable ground. And the repudiation of an MOU is by definition a statutory unfair labor practice. So I think it's the union's position that was sufficiently raised to the authority.
Thank you.
Now, the other main argument for why this court has jurisdiction is because the authority clearly has decided to exceed its statutory permissions given to it by 7122. These require the authority to defer to arbitration awards on grounds similar to those in the private sector. The grounds similar in the private sector rely on the Steelworkers Trilogy, MISCO, Garvey, and the Supreme Court has been very clear that if the arbitrator is even arguably construing the contract, this is the deference owed to his decision. And when you look at the authority's decision, where they expressly say, and then use this decision as precedent to continue to say, that we don't owe the same amount of deference to an arbitrator because public sector is different. This is clearly in excess of their statutory authority. And by doing that, that would give this court jurisdiction to hear this. And it would also make their decision arbitrary and capricious, because when you look at this court's ruling in National Weather Service, this court was very clear to the authority as to what standard it must apply. And it was the standard found in steelworkers. So when you get past those two jurisdictional issues, and I know I'm running a little short on time at this point, and you really get to the merits, the authority then decides that a binding past practice can't create a condition of employment, which is a private sector labor law concept that has been around for 40 or 50 years, which all of a sudden led the authority to pursue a faulty analysis of why the arbitrator's decision was not within the essence of the contract. Those are the main points that I wanted to make, and I know I'm over time now, so I'd submit to Ms. Blackadar for.
All right, Mr. Davis, we'll give you a couple minutes. Ms. Blackadar.
Thank you, Your Honors. And may it please the court, Sarah Blackadar for the respondents, the Federal Labor Relations Authority. The authority respectfully requests the court dismiss the union's petition for lack of jurisdiction, or in the alternative to deny it entirely on the merits. The case lacks jurisdiction for three reasons. First, the union has waived a number of the arguments that it seeks to bring before this court, and under section 7123C, those arguments are not properly before this court's jurisdiction. Second, under section 7123A, the statute clearly precludes judicial review of authority decisions that address arbitration awards that do not involve an unfair labor practice. This decision does not involve an unfair labor practice. And finally, the union's efforts to invoke a Leadham-esque-like claim of jurisdiction or jurisdiction similar to that in the custom service case are inapplicable here. Even if the court reached the merits of this petition, though, there is simply no grounds to overturn the authority's decision. The court has twice interpreted Article 18 and come to the clear conclusion that it states that shift reassignments and post changes are governed by Article 18. That is exactly what the union sought to negotiate over here. And the only way that the arbitrator could reach a decision that allowed or required the agency to bargain anew was to write an entirely new contractual term into the parties' agreement, not interpret the agreement as it exists. This is at the heart of an essence exception, and that is the reason the authority set aside this decision. But looking first to some of the arguments that were brought up here again today, the union has simply not raised these unfair labor practices either at arbitration or before the authority. It never argued that the agency's refusal to negotiate constituted an unfair labor practice under the statute, and it never even attempted to argue that the agency repudiated the memorandum of understanding before the arbitrator or the authority. This is quite clear because, as the union just pointed to, one page before in petitioner's appendix on page 148, the union is clearly stating that the arbitrator found that the agency violated 4 provisions of the parties' agreement and the local memorandum of understanding. Therefore, it is quite clear both their understanding, the agency's understanding, the arbitrator's understanding, and the authority's understanding of that award was it was based purely on contractual violations. This point, even if the union could have been more successful, although that is still doubtful, by bringing an unfair labor practice claim such as repudiation, it did not do so. Where there was no unfair labor practice to adjudicate before the arbitrator or the authority, this decision is barred by section 7123, but these arguments are also barred by section 7123C because they're new and raised to the court for the first time. The one reference to one case.
Ms. Blackadar?
Yes, Your Honor.
This court in BOP 1 and BOP 2 addressed an issue very similar to the issue that the arbitrator and authority addressed in this case. And we had jurisdiction in BOP 1 and BOP 2. So can you talk to us a bit about why we don't have jurisdiction here when we did have jurisdiction there?
Yes, Your Honor. In those two cases, we were talking about an unfair labor practice. That is evident from the fact that the issue at stake in both cases was the application of the covered by doctrine, which is a doctrine that relates to unfair labor practice cases. Now, the authority did cite to the court's decision in both of those cases because, particularly in Bureau of Prisons 2, the court was explicit that this isn't just a nuance of unfair labor practice law. This article is clear on its face what it means and what it covers, and it needs to be given that effect. And it chastised the authority for failing to understand and do that in a number of arbitration awards that were reviewed between Bureau of Prisons 1 and Bureau of Prisons 2. That's the only reason it comes up in this case, because the authority then goes on to explain that given this explicit and clear language in Article 18, the arbitrator's decision has to be based on his finding of a new contractual term, which the arbitrator created based on past practices and then awarded the remedies that he did in the arbitration award based on that new contractual term. This is, as the court has expressed in private sector labor law cases, a clear instance of the arbitrator dispensing his own brand of industrial justice, departing entirely from the terms of the party's contract and writing his own. And for that reason, it had to be set aside for failing to draw its essence from the party's agreement. But returning again to some of the other issues that our party has raised here, for example, even this argument that the authority can't deviate in any way whatsoever from steelworkers is new. And even though this was an issue that wasn't in play before the authority's decision, the court has repeatedly held that parties need to file motions for reconsideration with the authority, even to address sua sponte arguments, before they can bring their positions on those arguments to this court. That didn't happen in this case. And so again, under 7123A, essentially the arguments that the union is now relying on to set aside the award are outside this court's jurisdiction. But going more specifically to the heart of the issue here, where an arbitration award and an authority decision so clearly rest upon contractual findings, this case easily fits into overseas education, the court's earliest precedent on this issue, where the conduct could have been, but was not, characterized as an unfair labor practice by the parties during the arbitration. There is no jurisdiction in this court. Moreover, the court has been clear that a mere passing reference or the party's own efforts to raise ULPs after the arbitration are not sufficient. It is important. What is essential and important is what is in the arbitration award and what is in the authority's decision. And so for that reason, the court does not have jurisdiction in this case, even if there were some glancing references to unfair labor practices in the exceptions briefing. They are not in the arbitration award. They are not in the authority's decision, and thus there is no jurisdiction in this case.
Would you distinguish this National Weather Service employees from 2020?
Yes, Your Honor. In National Weather Service, the union characterized the exact same conduct, both explicitly as an unfair labor practice when it brought its grievance to arbitration and as a contractual violation. So although what they were talking about was the exact same alleged wrongdoing by the agency, they characterized it explicitly as both types of violations. When the arbitrator found that there was a contractual violation, but no unfair labor practice, the union filed exceptions with that determination, and the authority then decided whether or not the arbitrator was correct on the unfair labor practice issue, resulting in an authority decision that addressed both contractual violations and unfair labor practices. The union brought the case to this court, and the court said that as long as there is an unfair labor practice that is in the decision, the entire decision is on appeal. Here, there is no unfair labor practice in the decision, so none of the decision can be on appeal.
All right, thank you.
Your Honors, as I've noted here, the authority's decision is clearly beyond the jurisdiction of this court as it addresses only contractual claims brought through arbitration. Further, the arguments that the agency or the union brings to the court today are new in their brief for the first time, and thus also barred by statute from this court's jurisdiction. Finally, even if the court were to reach the merits in this case, there is simply no grounds to overturn the authority's decision, as it has correctly implemented the essence exception that exists in the private sector. And it clearly did not depart from or say that it would no longer use steelworkers as a guide. For these reasons, there's no grounds for jurisdiction under LEADM or Customs Service, where the statutes being interpreted apply to working conditions, and they were applied reasonably, as the authority has done throughout its history, and not set aside the precedent that the union says they do. For these reasons, we ask first that the court should simply dismiss this petition for lack of jurisdiction, and barring that, to deny it entirely on the merits.
All right, thank you. Mr. Davis, why don't you take 2 minutes?
Thank you, Your Honor. A few things I'd like to address. First, the arbitrator's award was based on multiple separate and independent grounds. So while the authority used statutory unfair labor practice law to support its decision, then Judge, now Justice Kavanaugh, in Undersea Warfare, pointed to that as an indicia of an unfair labor practice being involved. Moreover, when you look at the separate and independent grounds, this case can be distinguished from BOP 1 and BOP 2 on the facts that Article 27, the health and safety of workers, and the Memorandum of Understanding, which was entered into after the collective bargaining agreement, are both separate, distinct grounds, and by the authority erroneously finding that the arbitrator had relied on past practice and therefore the MOU analysis wasn't needed, they endorsed the repudiation of the MOU. That is sufficient to give this court jurisdiction. And once this court has jurisdiction, under National Weather Service, it's clear the authority's decision was arbitrary and capricious. In the petitioner's reply brief, we pointed that the FLRA has since, in multiple footnotes, cited to this case addressing the deference owed to arbitrators in the public sector. They have made it a point that as far as steelworkers goes, it's not the same for the public sector as it is the private sector.
All right, thank you. Madam Clerk, if you would call the next case.
Case number 20-5227, New LifeCare Hospitals of North Carolina, LLC, doing business as LifeCare Hospitals of North Carolina, et al., appellants, versus Xavier Becerra in his official capacity as Secretary, United States Department of Health and Human Services. Mr. Healy for the appellants, Mr. Fan for the appellate.
Mr. Healy, good morning.
Good morning.
Please proceed.
Thank you. May it please the court, my name is Jason Healy on behalf of the appellants. 4 long-term care hospitals who suddenly stopped receiving Medicare reimbursement for bad debts of dual eligible beneficiaries because the agency changed the reimbursement requirements under its so-called must-bill policy without notice, leaving the hospitals with no way to comply. The agency's action violated multiple sections of the Medicare statute, notably the notice and comment rulemaking requirement in the Medicare statute at section 1395 HHA2, the bad debt moratorium at section 1395 F note, and the cost shifting prohibition at section 1395 X V1A Romanet I. as well as the bad debt regulation at 42 CFR section 41389 and the Administrative Procedure Act at section 706(2). Therefore, the appellants respectfully request this court to reverse the district court and order HHS to calculate the reimbursement owed for their dual eligible bad debts without the must-bill policy or Medicaid RA requirements, plus prejudgment interest under section 13950F2 of the Medicare statute. This court's standard of review here is de novo for all issues. The court is to review the agency's record under section 706 of the APA to determine whether the agency's action was arbitrary and capricious and abuse of discretion, not in accordance with the law, without observance of procedure required by law, or unsupported by substantial evidence. And the court is to view the evidence in light most favorable to the hospitals, which is something we believe the district court did not do in this case. Now, these 4 hospitals are located in North Carolina, Pennsylvania.
Can I ask counsel, what is the policy that you are challenging, and when was that policy according to you, promulgated or initiated?
Thank you for the question, Judge Wilkins. And I know from your involvement in the Grossmont case, you're familiar with the must-bill policy under the bad debt reimbursement scheme for Medicare. This particular requirement at issue is the Medicaid remittance advice requirement. It's Medicare's determination the sole document a provider has to submit to support dual eligible reimbursement for bad debt is a remittance advice from the state, which is a payment determination made on the Medicaid claim. So that's what's at issue. The courts
when are you saying that policy was adopted?
The district court in this circuit has already determined that must-bill requirement with a Medicaid remittance advice was adopted in 2004 under the Joint Signature Memorandum 370. In this case, these hospitals received their dual eligible bad debt reimbursement without billing the state or submitting a Medicaid remittance advice from the state up until April 2008. So there's a period of about 4 years where the Medicare contractors were actually paying all the dual eligible bad debts without a Medicare remittance advice. And then suddenly, because CMS, the agency, instructed the intermediaries to impose the must-bill RA requirement on even non-Medicaid participating hospitals at that point in time, that's when they were subject to the must-bill policy. And the fact that the agency imposed that remittance advice requirement put them in what the district court has determined to be a catch-22. That clearly was the case here with these 4 hospitals.
Let me interrupt you, because what has confused me about this case is that your complaint and your briefing suggests that what you're challenging is a change that happened in April 2008. Because you say that prior to that, bills were being reimbursed even when the state hadn't been billed. And so that the change that occurred was in April 2008 when that stopped happening. So are you challenging an action or policy that happened in April 2008, or are you challenging the JSM in 2004?
We're not challenging the JSM in 2004. And I think, Your Honor, this is a clear distinction that I hope the court will appreciate in the briefing. These 4 appellants, they do not challenge the must-bill policy in general. For hospitals that participate in Medicaid, this may be an inconvenience, as in Grossmont, but it is something that's possible to accomplish. For these hospitals, it was impossible to actually bill the state. They weren't recognized as Medicaid providers and receive that remittance advice. So to answer your question, these hospitals do not challenge the JSM in 2004. They're challenging the agency's decision to impose the remittance advice requirement on these hospitals beginning in April 2008. Now, from the other cases decided by your district court, a number of decisions, the select specialty case issued by Judge Howell, the Kindred Healthcare case as well, We know that other long-term care hospital companies in the 2007 to 2008 timeframe also experienced the same change in policy by the agency, where the agency imposed this remittance advice requirement for the first time, thereby putting them in the position of having, in a catch-22, they couldn't bill the state, they couldn't get the remittance advice, therefore they couldn't get the Medicare reimbursement.
Now, I want to ask you about the administrator's ruling, because as I read the administrator's ruling at JA 731, this is page, I guess, 18 of the administrator's ruling. The administrator said, in so many words, the hospitals have alleged that they have been paid, that claims have been paid where even without state remittance advices, and that they were, exempt from this requirement. But the administrator said, that wasn't because of any agency policy. Maybe it happened, but it wasn't as a result of agency policy. Basically, mistakes happen, some things fall through the cracks. And so the administrator basically found that what you were challenging, as far as, whatever change happened around April of 2008, that change was not as a result of agency policy. And it seems to me that even though we review the district court de novo on summary judgment, we still employ the substantial evidence and or arbitrary and capricious review under the APA of the administrator's ruling. And so tell me why that finding that there was no policy that affected you wasn't supported by substantial evidence in this administrative record.
Your Honor, the fact is that the agency did not issue anything in writing stating this change in policy. Nevertheless, the evidence in the record, which includes the sworn testimony of the provider's witness, the director of reimbursement for the appellants, stated that the bad debt was paid without billing the state or remittance advice from the state in past periods. In fact, during this 4 years since the JSM was issued, it was only in April 2008 that the cost report started to be adjusted. And that's corroborated by the record in the other cases, Your Honor.
Let's suppose we accept that. It's paid by contractors. And if the contractors pay it in, either as a mistake or kind of in defiance of agency policy, but then the contractors start following agency policy, then that's essentially what the administrator seems to have found. Then how do you have a claim?
Well, Your Honor, Judge Howell, in a select specialty decision, determined that this was, in fact, a substantive change that was imposed upon the hospitals. The fact that they had to enter into contracts with the Medicaid programs to participate, which they previously didn't have, when Medicaid participation is not a requirement under the Medicare statute or the regulations to be reimbursed by the Medicare program. And therefore, it fits within the ALENA structure of rationale that this is an interpretive rule, but it had to go through notice and comment rulemaking. The fact is that the appellants here did not receive any notice whatsoever that they would have to comply with this Medicaid remittance advice only requirement, even after the JSM was issued. And so had they received such notice, Your Honor, they certainly would have tried to enroll with these Medicaid programs sooner, or convince the agency through the comment process that it was not a good policy, that there needed to be some exception, which in fact was the case leading up to April 2008 for these particular hospitals.
All right, Judge Walker, do you have any questions?
I don't. Thanks, Judge Henderson.
All right, we'll hear from Mr. Fan.
Good morning. May it please the court, Dennis Van on behalf of the United States. I just wanted to pick up on a question that Judge Wilkins was asking about with respect to, the non-Medicaid participating aspect of all this. The must-bill policy has been in place for the better part of 4 decades, and we cite to the PRM manual provisions that have been in place since 1974 on this, and it's never let a hospital exempt itself from the policy by dropping out of Medicaid.
Mr. Fan, did the RA requirement go back to the 70s?
The RA requirement was part of the intermediary manual, and at least that we cite to some other provisions that were part of the intermediary manual. But I just want to point out that at least the basic must-bill policy, the fact that you need to bill the states, has always been in place since 1974, and it's never included an exemption where if you want to get out of.
How far back does the RA requirement go?
The RA requirement, we think at least goes back to before 1987, which is before the bad debt moratorium, and we discussed this briefly on page 21, I believe, of our brief. The one point I'll want to address with the RA requirement is I actually don't think it matters here at all. As this court found in Grossman, and just to back this up a little bit, there's 2 requirements. You submit a bill to the states and to the state Medicaid system, and then you wait. The state says, here's my determination. This is how much, the state Medicaid system owes you. Plaintiffs here haven't even gotten past that first step. And the district court decisions that they cite all address the second step. I think they actually, all those decisions in a way support us. Mercy General, for instance, says that there's 2 steps of this, and the provider has to meet the first one first. They have to first go out there and go build the state Medicaid systems.
Mr. Fan, I take that point, but the second requirement, the second part, the RA requirement, I know you just said it goes back to before 1987. It would be helpful if you can point to a date that it originated. Can you tell us the year it originated?
I can't tell you the exact year that it originated, Your Honor. What we cite to is a 1985 intermediary manual, and I misstated this. It's on page 26 of our brief. We cite to a 1985 intermediary manual. These manuals are updated periodically. We cite to the 1974 PRM, for example, in our briefs. There's earlier versions of that PRM from before 1974. It's just that those aren't in the record, and usually in the administrative process, the government or the contractor submits some version of the pre-1987 manual. But the one that we're citing to is since at least 1985, and it says
let me go back. Oh no, please finish that sentence.
Oh, and it says that you need to have a written notice of rejection from the states, and that's the RA requirement.
That's the exact same thing as the RA requirement?
Yeah, I actually think a lot of these district court decisions, if you want to sort of get down to brass tacks on this, stem from a confusion about sort of jargon and the jargon that's changed in the Medicare and Medicaid setting over the past 4 decades. I'll be the first to admit that they didn't use the words remittance advice in 1980. They didn't talk about it in that way. Remittance advice is kind of a funky term. But the thing they did say is you need to go to the states, you need to get a state determination. That's exactly what this court said in Grossman. That might be called a remittance advice. It might be called a rejection letter. It might be called a reimbursement denial. It might be called any number of things. And I think that's one of the things that district courts in this area have gotten hung up on a little bit, where they look at the 1985 manual.
Let me ask about those decisions. Do you think that they have any kind of, or should have any kind of estoppel effect on the district court in our case? And I take it you probably don't. think that. So if you can kind of walk me through, the government were certainly well represented in those cases. The district courts found violations of the 1987 moratorium. Select found that there was a change in policy. And then the district court in our case did not attribute any kind of estoppel effect to those. I'm not asking about stare decisis effect. I'm asking about estoppel effect. So can you kind of talk me through why there should be no estoppel effect?
I mean, there's of course no non-mutual collateral estoppel doesn't apply against the government. But beyond that, I mean, there's a host of complicated factors about when the government takes appeals from adverse decisions, and all those district court decisions did was remand those cases back to the agency for the agency to decide what amount of reimbursement was due. And I do want to address those decisions real quick, because I think there's 3 of them. As I mentioned, Mercy General really does help us, because it says you really have to get through the must bill, like the billing requirement first, which is exactly what these particular plaintiffs have not done, because they've tried to exempt themselves entirely out of the Medicaid billing system. The other 2 decisions in Select Hospitality, in Select Specialty, and in Kindred, we disagree with in their entirety. I mean, Select Specialty says there was a change in policy because contractors applied pre-existing policy to the hospitals in those particular cases. The Supreme Court has made very clear that contractors don't have the authority to resolve policy questions. Contractors can't override CMS policy. They can't override the administrator's policy. And that's for a really good reason. There are thousands of providers and hospitals out there. If they get approved for some sort of reimbursement and they shouldn't have gotten approved, that will never reach CMS's attention in most cases. That's because
Mr. Fan, the government appealed Select, and then a few days later, after the appeal, it withdrew its appeal. If Select was wrong, as you just said, why drop that appeal?
I can't get into the reasons why the government made certain decisions about whether to appeal or not. I will say the government is pretty judicious about when it decides to pursue appeals and when it doesn't decide to pursue appeals, and that's a determination that the Solicitor General has to make in individual cases about whether to pursue an appeal. So you can presume in that instance.
Fair. Let me ask one more question. Then I know I apologize to my colleagues for going on as long as I have. But one more question on the district court's finding that there was a forfeiture on the 1987 moratorium argument or point. What do you think the standard of review for us is in assessing whether the district court erred in finding forfeiture?
Yeah, I think that's, what I'll say is, the board only addressed certain types of issues when the bad debt moratorium came before the board said, the requirement to bill passes the bad debt moratorium, and that was never raised before the administrator. And when it got to the district court found that that had been waived and it wasn't fully developed in the record. I think it's fully correct, at least for this court, to just say that, there wasn't actually a developed argument about the RA requirement as presented to the board and as presented to the administrator. I don't think we need if this were a question of whether an argument was developed in the trial record, I think we'd be in sort of abusive discretion land for sure. But in terms of identifying which issues were in front of the board or actually addressed in a board decision, that seems to be a fairly straightforward kind of legal inquiry. And I just want to point out with the waiver question, I don't think the waiver question is just whether sort of in the abstract, whether they've waived the bad debt moratorium. It really is, have they developed this argument before the board? what they included was, a short section that was about a page and a half in the legal standard section of their final post-hearing brief, with no citations to any policy that the secretary had changed, no announcement of any policy of the secretary changing any sort of policy. And the board said, well, like, the only thing that we think you've raised is the billing requirement that's been in place for many decades. And if there are no further questions, I see my time has elapsed and this court should affirm.
All right, Judge Wilkins, any questions?
No questions.
All right, Mr. Healy, why don't you take 2 minutes?
Okay, thank you very much. Just to respond briefly to some of the points raised by Mr. Fan. The first point is with regard to date for the remittance advice requirement. As I stated previously, that wasn't enunciated until 2004 in the JSM. The Kindred Healthcare case actually dealt with a very careful review of all those prior documents going back to the 1980s and previous, and determined that the specific Medicaid remittance advice requirement is not contained in those documents. In the select specialty case, Judge Howell also addressed those documents, even though they weren't before the court officially. And so it's disingenuous for the government to say that there was in fact a remittance advice requirement dating back to before 1987. With respect to Judge Walker's questions about the Mercy, the Kindred, and the Select cases, the fact is the government did not appeal those decisions. The Select specialty case was appealed but withdrawn. The government has not defended its position in those cases, and we believe those 3 decisions in particular form a constellation of decisions that all reach the same point of view, the same judgment, that this change in fact did occur with the must-bill policy applying this remittance advice requirement to non-Medicaid participating providers at the same time, which created this substantive legal standard imposed upon them. And that violated that notice and comment requirement in the Medicare statute. And also the 2 cases, Mercy and Kindred, decided violated the bad debt moratorium. If I could just address the waiver issue very briefly, I would note that we had briefed the bad debt moratorium arguments quite a bit in our position paper. It was discussed at the PRB hearing. It was in our post-hearing brief. It was addressed in the PRB decision, and to some extent was actually discussed in the administrator decision as well. But we believe the court clearly erred in finding that this was an adversarial process at the administrator review level when it doesn't have any of the hallmarks under the Sims Supreme Court case for being an adversarial proceeding. In fact, lined up with all those factors in Sims for determining that it was not adversarial. And we think the court should have not created a judicially imposed waiver requirement for this process that's been in place for about 50 years with the PRB and the administrator. I've practiced before the board administrator for 20 years, and we've never had this type of rule. These are comments only, optional, and submitted to the administrator solely for their consideration as they do a plenary review of the PRB decision and the entire record. So I submit to your honors that that was a clear error by the district court. And this is actually an area where this court can review that issue de novo under the Koch versus White case that the circuit issued in 2014, that issue exhaustion requirement can be reviewed de novo to answer Judge Walker's question. I see I'm over my time.
All right.
Thank you very much.
Thank you, counsel, and your case is submitted.
This honorable court is now adjourned until Friday, April 23rd at 9:30 a.m.